It's time for a Mississippi judge to go back to law school or leave the profession. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. There are certain things in the law that every lawyer and every judge knows. They know the three branches of government, what the First, Second, Fourth, Fifth, and Sixth Amendments do, and they understand large blocks of substantive law. But fundamentally, they understand the Constitution and the First and other amendments to the Constitution. Now, some of those things are things that you learn in high school if you have a good one, and in college if you don't. Then in law school, you get a lot more depth on all of these different things. Each amendment, each section of the Constitution, each article has a lot of different parts to it. And there are sometimes 5 or 6 word phrases in an amendment or in a constitutional provision that get called out in cases. And there's so much depth in the area of constitutional law that to be a good lawyer, you have to understand how to do the research and what the basic premises of the Constitution are. One of the most important parts of the Constitution in terms of its impact on an informed populace is the First Amendment and the protection that the First Amendment provides to the press for publishing information. Now, the press is not required to be 100% accurate. If it was, there would never be a free press. There are certain exceptions that are made. You can't knowingly lie about someone, that is defamation. And defamation can pass muster under the First Amendment if it's done in a way so as to envision actual malice. But the First Amendment is also why you can't sue someone for sharing their opinion about you. For example, if they call you a dog faced pony soldier, or they call you a maggot, or anything else that's pure opinion. I mean, clearly, if someone calls you a maggot, it's not a fact, it's an opinion, and opinions are protected. We have that protection because many times opinions about facts are in some ways more important than the facts themselves. It's what allows Rachel Maddow on one side and Sean Hannity on the other to offer political opinions that send politicians into seizure like tirades. And having an opinion and sharing it are clearly protected for everyone, but even more so for a free press. Now, you may wonder why I'm talking about the First Amendment. Every now and again, a politician and a lawyer and a judge get together and they get their knickers in a twist over something somebody said or wrote, and they decide to do something about it in a way that they really shouldn't. You may recall in Kansas last year, we had the Marion, Kansas newspaper and the seizure of its computers by law enforcement because someone got a myocardial infarction sized case of hemorrhoids over an article criticizing a public official, who then used the cops to seize the paper. That's not supposed to happen in America. And the folks in Kansas taught the people involved a distinct lesson about that. Police chief lost his job, and I think the judge who granted the action or granted the warrant to seize that stuff, I think he suffered electorally. But usually, that is not the kind of thing that happens. Usually, government doesn't go after the press. But unfortunately, it has happened again. This time it's in Clarksdale, Mississippi. The local paper down there ran an editorial pointing out that the city government did not give proper notice of a meeting where it planned to impose an additional tax on cigarettes and alcohol and maybe even marijuana. The editorial got a fact or two wrong, but the editorial was on the opinion page. I mean, think about that. It's opinion. While one or two of the facts might have been incorrect, that doesn't justify prior restraint. and the Supreme Court has been clear that there be no prior restraint in the press in the United States. Let's look at this ridiculous order. The order says this matter having come before the court on a verified petition of the city of Clarksdale requesting a temporary restraining order or a hearing on a preliminary injunction, and after review of the verified petition, the court finds the petition is well taken. The injury in this case is defamation against public figures through actual malice in reckless disregard of the truth and interferes with their legitimate function to advocate for the legislation they believe would help their municipality during this current legislative cycle. The respondents are well aware of the accusations against them as they've already received a draft of the verified petition, and further notice is not needed until such hearing. The temporary restraining order for respondents to remove this article, the editorial, secrecy and deception erode public trust from their online portals and make it inaccessible to the public is hereby granted. Petitioner shall post a bond in the amount of $100 as security. That's the order, and it's really unbelievable, at least to me. The First Amendment, which protects freedom of the press, was adopted on December 15, 1791, as a part of the Bill of Rights. And the Bill of Rights provides lots of constitutional liberties to everyone, including the freedom to be free from unreasonable searches and seizures, and freedom of the press. And the reason freedom of the press was thought to be so necessary is that the British government had a history of going after and trying to censor local newspapers and prevent them from publishing stories that were critical of the British administration of the colonies. One of the first court cases involving freedom of the press in the United States involved John Peter Zenger, who was the publisher of the New York Weekly Journal. He wrote an article or editorial content that was critical of the government. They sued him for defamation and libel, and Zenger was acquitted because back then, libel could be a criminal offense. In 1776, the Virginia Declaration of Rights said, "The freedom of the press is one of the greatest bulwarks of liberty and can never be restrained but by despotic governments." In other words, the only people who restrain the press are tyrants. James Madison adapted that statement and he incorporated it into the First Amendment. In recent years, the New York Times has been a frequent target of folks who got their panties in a wad because they were supposedly defamed by stories there. And we have to go all the way back to 1963, 1964 to find a really good example of that. In New York Times versus Sullivan, the Times ran an ad seeking contributions on behalf of Martin Luther King. Sullivan was an elected official in Montgomery, Alabama, and he brought suit in a state court alleging that he'd been libeled by an advertisement in the newspaper, the text of which appeared over the names of 4 individual petitioners and many others. The advertisement included statements, some of which were false, about police actions allegedly directed against civil rights demonstrators and the leader of the civil rights movement. The respondent, Sullivan, claimed the statements referred to him because his duties included supervision of the police. The trial judge instructed the jury that such statements were, quote, libelous per se, meaning legal injury is implied without proof of actual damages, and that, for the purpose of compensatory damages, malice was presumed so that such damages could be awarded against petitioners if the statements were found to have been published by them and to have related to respondent. As to punitive damages, the judge instructed that mere negligence was not evidence of actual malice and would not justify an award of punitive damages. He refused to instruct that actual intent to harm or recklessness had to be found before punitive damages could be awarded, or that a verdict for respondent had to differentiate between what was compensatory and what was punitive. The jury found for the respondent, and the state Supreme Court affirmed a $500,000 verdict, which in 1964 was real money. Not so fast, SCOTUS says. There were so many things wrong with the trial court's instruction that the Supreme Court had to set the record straight in what has been one of the most sentinel opinions ever written by the Supreme Court. First of all, it established the actual malice standard for defamation. And malice doesn't mean malicious in thought. What it means is actual knowledge that what you're posting is factually incorrect or factually false. And they did that under the rubric of the 14th Amendment. Although it was dicta, it also said this: we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, wide open, that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on the government and public officials. In a later paragraph, it said, quote, the censorial power is in the people over the government, not in the government over the people. It would give public servants an unjustified preference over the public they serve if critics of official conduct did not have a fair equivalent of the immunity granted to the officials themselves. We conclude that such a privilege is required by the First and 14th Amendments. Then, in 1971, in the midst of the Vietnam War, which hopefully many of you are not old enough to actually recall, I actually lived through that. I was in the Philippines in 1971. The United States military analyst Daniel Ellsberg gave copies of classified documents to the New York Times. The documents, which would become known as the Pentagon Papers, detailed a top secret Defense Department study of the U.S. political and military involvement in Vietnam. The Pentagon Papers exposed the government's knowledge that the war would cost more than they were told and that there'd be a lot more lives lost than they were told. And it implicated the administrations of Truman and Eisenhower, Kennedy, and Johnson, said they had all misled the public about the degree of U.S. involvement in Vietnam. Well, the government went out and obtained a court order preventing the New York Times from publishing more excerpts from the papers. Remember, this is during the Nixon years, arguing that the published materials were a national security threat. A few weeks later, the U.S. government sought to block publication of the papers in the Washington Post as well, but the courts refused to honor that request that time. In New York Times versus the United States, the Supreme Court ruled in favor of the newspapers, making it possible for the Times and the Post to publish the contents of the Pentagon Papers without risk of further government censorship. So you can see what the judge has done here in Mississippi is never going to be allowed to stand. The Freedom of the Press Foundation said this about the Clarksdale case: it's hard to imagine a more unconstitutional order than one compelling a newspaper to take down an editorial critical of the government. And it's particularly ironic when the editorial in question is about government secrecy undermining the public trust. If anyone previously trusted the secretive officials involved in the censorship campaign, they shouldn't now. The underlying lawsuit here appears frivolous for any number of reasons, but even in constitutionally permissible defamation lawsuits, it's been well established law for decades that the remedy for plaintiffs is monetary damages, not censorship orders. This case should not be viewed in isolation. It's part of a nationwide increase in baseless censorship orders known as prior restraints. But this one is uniquely egregious. City Attorney Melvin D. Miller II and all the other lawyers involved in asking the court to silence the press should face real consequences, as should Judge Crystal Wise Martin, who rubber stamped their request. Judge Martin shouldn't be adjudicating parking tickets, let alone First Amendment cases. That was the Freedom of the Press Foundation. Well, what's worse, when the judge issued that TRO, she set a bond, and that bond is supposed to be able to provide damages to the defendant if the order is deemed to have been issued in error. The judge here set the bond at a ridiculously low level of $100. They probably lost that much in the first hour after that request went live. But here's the funny thing about this in one respect, and that is we have a perfect example of the Streisand effect here. By virtue of shutting the door on this editorial and hiding it away from the public, all they've done is increased the desire of every citizen in Mississippi to read this editorial. And they will get a chance to read the editorial. But more important, all of the content of the editorial, just not the actual words, are being disseminated by virtue of the freedom of the press and the ability of other people to talk about what this judge did and why it was so absolutely wrong. The order in Clarksdale, like I said, will not stand. That a judge felt privileged to issue it is what's really scary. That judge needs to go. And the lawyer who pleaded that case out should be disciplined. because he swore an oath to protect and defend the Constitution when he was sworn into the bar. You don't get to protect and defend only the parts of the Constitution you like. It's all or nothing. If you live in Mississippi, consider filing a complaint with the Judicial Discipline Commission and with the state bar. Some things should not ever be shrugged off. So that's what I have for you today. Thank you so much for watching. If you have different views on this, let me know. Otherwise, I'll catch you back down here tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.